Precedence Cases, Fairness in Employment Practices, presented by Frank Tadaro for CUNY School of Professional Studies, Course Personnel Selection, Psychology 680. What are precedence cases? A precedence, a case or issue decided by a court that can be used to help answer future legal questions. Usually, legal cases decided by courts such as the district courts and oftentimes the Supreme Court. These cases are usually the first of their kind, hence the legal decisions ruled by the court serve to act as a guide or a precedent. As we see, case law which serves as a precedent to guide but not to completely determine future legal decisions. In other words, just because a case, for instance, as we saw last time, the Driggs case, in future cases, the court cannot just simply refer to that case and hand out or decide a decision for that current case. And we'll go over a couple of cases, brief cases, and the general principles we'll discuss, and the laws and statutes which apply to those cases, as we see 1964 Civil Rights Act, Title VII, and the Civil Rights Act of 1991. General case law and the general principles, let's briefly go over 4 of them. Number 1, the law prohibits not only open and deliberate discrimination, but also practices that are fair in form but discriminatory in operation. And this applies to Title VII, which prohibits practices having an adverse impact on protected groups unless they are job related. And also protected groups are people that have an unfair advantage. Number 2, in cases of employment practice, fair practice, the employer bears the burden of proof, not so much the plaintiff. And this was according to the Civil Rights Act of 1991. According to Cascio et al., when the charge is made, the plaintiff must identify a specific employment practice as the cause of discrimination. Number 3, it is not necessary for the plaintiff to prove the discrimination was intentional. The intent is not relevant. The result is that the discrimination that occurred was unlawful. Number 4, job-related tests and other employment selection procedures are illegal and useful. Also, we saw this in the Driggs case. Tests must apply to job-related tasks. Here we see a couple examples of precedent cases relating to issues of workplace fairness. Meritor Savings Bank versus Vinson from 1986. This concerns sexual harassment in the workplace. The plaintiff argued that she was the subject of sexual harassment, although she did have a relationship with her supervisor. The court ruled that any relationship between the plaintiff and the employer was voluntarily, and this set the precedent for what we now know as a human resource rule, that any two parties or groups who decide to engage in a relationship in the workplace must notify human resources. That way human resources can record the relationship, and any future discrepancies down the line can be referred to that. In the next case, Trans World Airlines vs. Harrison claimed religious discrimination, in which the plaintiff claimed it was a violation of 703 Section A, religious discrimination. Hardison was transferred and could not work on Saturdays due to his religious belief in observance of the Sabbath. The court ruled that Trans World Airlines had not fulfilled its obligation of observing religious practices. Fairness in the workplace and employment practices. Well, look at this. As we saw in the Driggs case, disparate treatment theory, unfair discrimination is based on an intention to discriminate and to retaliate against the person who opposes discrimination, as cited in Cascio et al. 2015, page 16. Some cases are proved through circumstantial evidence of the intention to discriminate. There can be mixed motive cases that often rely on both direct evidence of the intention to discriminate. Adverse impact. Discrimination occurs when identical standards or procedures are applied to everyone, despite the fact that they lead to substantial differences in employment outcomes, such as selection, promotion, and layoffs. And all these are in accordance with the Equal Employment Opportunity Commission, the EEOC, where the plaintiff has 180 days to file a complaint. Some IO strategies to improve fairness and employment practices and organizational implications. Organizations can send messages to reduce harmful effects of stereotypes in the workplace, such as signs, memos, symbols. Employees are motivated when they feel that organizational resources are allocated fairly, that the organizational decisions are made in fair ways, and that the organization treats them fairly. You can also do this during the selection process, at job recruitment fairs, as long as employees know up front they feel they will be treated fairly. Concerning stereotypes, they can lead to workplace discrimination, especially when the stereotypes are unfair or indicate a negative stereotype. Overall, strategies by organizations should be implemented on the onset of the selection process and be reaffirmed periodically and routinely during the employee's tenure at the organization. This will increase employee motivation and the perception of being treated fairly by the organization. Thank you very much.